Let's read the book, The Scottish Enlightenment, The Scots Invention of the Modern World by Arthur Herman. This is chapter 4, The Proper Study of Mankind. 2. The faculties of the mind have been explored, and the affections of the heart, but there is still wanting a history of the species in its progress from the savage state to its highest civilization and improvement. Lord Keynes. The first section. Henry Home was the son of a landed gentleman from Keynes in Berwickshire. His mother was the granddaughter of Dr. Robert Bailey, principal of Glasgow University and an enthusiastic Covenanter in the 1640s. Quote, I furnished to half a dozen of good fellows muskets and packs. End quote. Bailey wrote the year the National Covenant had spread like a wildfire across the South lowlands, and to my boy a good broadsword. Home, who later took the title Lord Keynes, may have inherited his ancestors' fire and spirit, but the Kirk's legacy of a pessimistic moral austerity left no discernible trace. Instead, he was raised an Episcopalian and learned early on the importance of a good income, as well as the pride and pleasure of being a gentleman farmer, especially when others do the heavy lifting. He attended no school or university, but was tutored at home. Since he showed a predilection for books and learning, it was decided that the perfect profession for this heir to a modest country fortune was the law. In 1712, just the year after Francis Hutchinson arrived at Glasgow, 16-year-old Harry Home set off for Edinburgh to start his legal education in the chambers of John Dickinson, a so-called writer of the signet, or what the English would call a solicitor. This was more than just a matter of terminology. It reflected a genuine difference between the legal systems of the two countries, and even a difference in the mentality of those who took up the study and the practice of the law. Scottish law had developed very differently from its English counterpart. They sprang up at almost the same time, in the 12th and 13th centuries. But as time went on, the outlook of English lawyers and judges became increasingly insular. They looked to the custom and the precedent of their own past to settle virtually every dispute. Hence the term common law, meaning common to the Kingdom of England. The Scots, on the other hand, who had learned to cast wider for their fundamental legal principles, turned to the ancient Rome civil law. They studied the medieval legal scholars, the great civilians, who were busy reviving that Roman legacy on the continent. This meant that by John Knox's time, Scottish law looked more like that of France or Italy than Scotland's neighbor to the immediate south. In fact, many Scottish lawyers in the 17th century still went to France to complete their law training rather than to England, since the English legal principles made little or no sense to the Scottish mind. The two systems have some elements in common. To bring a case to court, a person hires a solicitor, or in Scotland, a writer, who in turn finds a barrister, in Scotland called an advocate, to plead the case for his client before the judge. There, however, the similarity ends. The relationship between plaintiff and the defendant is more than simply adversarial. The prosecution makes no opening statement. The evidence against a defendant must speak for itself. Judge and jury, and in Kemp's times, there were no juries in civil trials, carry an awesome responsibility. Unlike his English and American counterpart, the Scottish magistrate does not just ask what the evidence proves. He dares to pose a crucial question: what really happened? A Scottish judge's decision in a civil or criminal case looks beyond the facts to the underlying principles of fairness and equity that the case involves. His guide is not precedent but reason, hence the importance of a Roman law, which later commentators even refer to as written reason. Since the Middle Ages, in fact, Scottish legal minds had come to rely on Roman law to fill in the gaps in their own law. The judges of the Court of Session were even designated senators, as if they were the successors to the ancient Roman body. The first professor of Scots law at the University of Edinburgh, Alexander Benny, explained, quote, "We consider the Roman laws, which are not disconform to our own fixed laws and customs, to be our own law." End quote. Later, as a distinguished judge, Lord Kemp's would agree, quote, "Our law is grafted on that of old Rome." End quote. He would write, quote, "The Roman law is illustrious for its equitable rules, affording great scope for acute reasoning." End quote. It taught a judge, above all, to think independently and not to worry too much about what other judges had said in the past. It also taught another invaluable lesson, firmly established in Scottish jurisprudence, that no person, not even a monarch, stood above the law. The one Scottish institution left untouched by the Act of Union in 1707, besides its kirk and its universities, was its legal system. Parliament House, once the home of a self-government, now became the home of the law courts. When the teenager Henry Home visited for the first time, he would have been judges, striding back and forth to court in their magnificent maroon silk robes. The bustle of attorneys and bailiffs summoning clients to court, and he would have heard the cries of shopkeepers peddling their wares from their booths in the nearby streets and alleys. It became the center of his world. For the rest of his life, he never lived more than a few blocks from Parliament House. Apprenticing with a writer of the signet, so-called from the royal signet ring used to authorize legal documents, was a typical way to start one's training in the law. Working with Dickinson immersed Home in the complicated legal issues arising from the sale and alienation of land, and establishing hereditary title. He would have spent hours mastering the arcane rules and vocabulary of Scottish feudal land holding, a mixture of Norman French, Middle English, and Scots. First came the various kinds of tenure, such as ward, fuel, blanch, baggages, and mortification. Then the obligation owed to landlords, bonds, contracts, tax, a type of a lease, warsets or mortgages, renditions, and the bills of bottomry. He would have learned how the landholding of feudal Scotland, in both highlands and lowlands, had been created out of military necessity. This archaic system of land ownership had survived in Scotland much as it had elsewhere in 18th century Europe, although the Scots had organized and systematized it better than most. But since then, new forms of property holding, buying, selling, and leasing of land and movables had arisen, which both overlapped and challenged the old patterns. Who was more in the right, the old landholders or the new? It was the kind of question that would occupy Home later on, and he could not have begun to address it without his earlier training in Dickinson's chambers. Holmes' interest in the law took a sharply different turn when he met Sir Hugh Dalrymple, Lord President of the Court of Session. Dalrymple was the brother of John Dalrymple, Viscount Stair, who had died while pressing the Act of Union on a reluctant Parliament. Their father, the first Viscount Stair, was the distinguished organizer and systematizer of Scottish law, whose institutions were published in 1681. The supposed Dalrymple course left no mark on the elegant and convivial Sir Hugh. Just the opposite, Home himself described the first time as a struggling young law clerk he met Dalrymple, and how it changed his life. Quote, I was kept waiting in an after room. I heard delightful music upon a harpsichord in the next room, and I meditated on the hardship of there being such distinctions amongst mankind. Quote, why are the people in that room enjoying such happiness, and I kept in a mean, drudging way? Were I but fortunate enough to be on the other side of the wall? End quote. End quote. There was only one way. This was to switch from the straightforward but less lucrative profession of a writer or solicitor to the more glamorous but also more competitive world of the advocate or barrister, who represented clients in court and commanded high fees for doing so. It was also from their ranks that the future judges for the Court of Session and the Court of Justiciary, Scotland's highest criminal court, were chosen. Home quickly made up his mind. He became close friends with the Dalrymple family. The son became his roommate, and the music of the family she chord became a familiar sound to young Harry Home. He also threw himself into the studies necessary for admission to the faculty of advocates. Scottish advocates had been practicing before the bar since the 13th century and had formed their own guild, the Faculty of Advocates, in the 16th. The rules for admission had become increasingly strict, even scholarly. The faculty required from its members a full course of study of philosophy and law at a university for at least 2 years, in lieu of a formal experience for 7. The contrast with England was striking. The English barrister received no formal academic training at all. Instead, he learned his trade at the Inns of Court in London entirely in the old medieval style of hands-on apprenticeship. Like his celestial counterparts, the young English barrister learned to follow the leader and to obey the dictates of a precedent, because there was no practical alternative. But his Scottish counterpart was as much the product of a rigorous scholarly erudition as of practical skills. 2 years of overseas study at universities in Holland or even in France gave the Scottish bar a cosmopolitan air the English never achieved. It also immersed the aspiring advocate even deeper in the theory of Roman and civil law. Justinian's Codex sat on Holmes' desk side by side with Steyer's institutions as he prepared for his final examination. Since 1664, the faculty had required a private and public exam on the civil law administered by senior advocates, and a public speech on a civil law text chosen by the dean of the faculty. Home presented his on 17 January 1723 on a subject familiar from his days, studying to be a writer to the signet, the revocation and the transference of legacies. He was now a full-fledged advocate and a member of the Scottish bar. He was 27 years old. Harry Home proved to be a rising star. His tall, stooping figure, as his friend Alan Ramsay described him, and his keen, sarcastic face became a familiar sight around Parliament House and in the neighboring taverns and oyster houses. Men and women alike found him captivating, and the poet William Hamilton described him this way: while crowned with radiant charms divine, unnumbered beauties round thee shine. As he then admitted to James Boswell years later, I got into pretty riotous and expensive society. When he found himself swamped with bills and over £300 in debt, he put the brakes on his social life and concentrated on the work. Let me stop here for this episode.